So, a federal district court in California just issued a preliminary injunction against the California handgun roster. So, let's talk about what this means and where do we go from here. But real quick, before we jump in this video, I want to actually thank the California Rifle and Pistol Association, who is the organization responsible for bringing this case, Michelle and Associates, who were the attorneys involved in this, Reno May, and all the other plaintiffs who were involved in this case. Thank you to them for actually litigating this case, bringing this case. And I just wanted to mention to you guys, if you want to support an organization in California that is doing the right thing, that is fighting the fight for us here in California, I highly recommend you donate to CRPA. I will leave a link to them down below where you can donate to them and become a member. And again, CRPA is one of those state level orgs that is actually doing the good work. So like I mentioned in the intro, a federal district court in California just issued a preliminary injunction against the state of California's Unsafe Handgun Act. And that is most commonly known to most people as the California handgun roster. The case we're going to be talking about in this video is called Bolin v. Bonta. This lawsuit challenged the constitutionality of the handgun roster in a post-Bruin world. For those not aware, in California, there is a law which places certain requirements and restrictions on handguns for them to be deemed safe for sale to the average law-abiding person. The UHA requires that handguns be drop tested to determine whether they are safe from accidental discharges and be equipped with certain safety features to be sold in California. Those features and those safety features that must be present under the UHA includes loaded chamber indicators, magazine disconnects, and also microstamping. In this lawsuit, the plaintiff sought a motion for a preliminary injunction. A preliminary injunction is simply a finding by a court that the plaintiffs are likely to win the case on the merits of the case and that there was irreparable harm that was done to those plaintiffs. Well, a federal district court judge, Cormac Carney, just granted the motion for preliminary injunction against California's handgun roster. So the court is enjoining various aspects of the Unsafe Handgun Act, and they are enjoining the microstamping requirements, the loaded chamber indicator requirement, the magazine disconnect requirement. So that's what he's enjoining. This would open the floodgates for the average person to be able to purchase these types of handguns that they've been banned from being able to purchase prior, unless they went off roster or private party purchases. However, as you saw noted in that judge's decision, this will not go into effect for another 14 days. That means that California has, I believe, until April 3rd to appeal that decision up to the Ninth Circuit and to also seek a further stay from the Ninth Circuit. Now, there is kind of a caveat that I think is going to take place with this stay that I'm going to mention at the end of this video, so stay tuned for that. And it has huge implications because what we've seen play out in the Second Circuit and some of the hearings that just played out today at the Second Circuit level. For those, however, who are asking if you can go out right now and purchase a handgun that's off roster, if you can walk into a store and purchase one, the answer is no, not right now. We have to wait at least 14 days to see how this plays out. And really, it's probably going to take a little bit longer because all these companies and manufacturers are going to have to submit these to the DOJ to get them put on the roster. Now, one of my favorite sections of this entire decision is when the judge here calls out California for their BS and their whole public interest arguments for why they need the handgun roster. The judge states, the government cannot credibly argue that handguns without a loaded chamber indicator, a magazine disconnect, and microstamping features pose unacceptable public safety risks when virtually all the handguns available on the roster and sold in California today lack those features. Similarly, if off-roster firearms were truly unsafe, California would not allow law enforcement to use them in the line of duty when the stakes are at their highest. But the substantial majority of California's law enforcement officers use off-roster handguns in the line of duty. Indeed, the government's own witness, Special Agent Salvador Gonzalez, testified that he uses an off-roster duty handgun without a CLI, an MDM, or microstamping capability. If CLIs and MDMs truly increase the overall safety of a firearm, law enforcement surely would use them, but they do not. Instead, they choose to use newer, improved, and safer generations of handguns that are off-roster. There in that language, you see the judge calling out the fact that law enforcement officers, primarily in the state of California, are using off-roster handguns. Also, the state of California permits people to purchase off-roster handguns through the secondary market, They're not banning that either. So if these were so unsafe, why are they still permitted to be carried by law enforcement? They are used primarily by law enforcement, and they're also in circulation in private party transactions. Now, some of you may be asking at this point, okay, I understand the decision, a preliminary injunction was issued, but practically, how is this going to operate? Where do we go from here? Well, like I mentioned at the beginning, the decision does not go into effect for 14 days. The judge here put a temporary stay on his own judgment. The state of California now has to decide if they want to appeal this decision up to the Ninth Circuit, which in my opinion, they most likely will. Typically, there's a revolving panel of judges that will decide on whether or not to grant these stays. We won't know who the judges on this panel will be. We will likely not know until they deny or grant the state of California stay. But let's say by some miracle that the Ninth Circuit does not stay the lower court's decision. Well, then maybe what's going to happen? Well, maybe operationally, there's going to be a ton of manufacturers that will submit their handguns to the DOJ for approval, and they will seek for the DOJ to place those on the roster. To me, one of the most concerning things about all this is likely that the DOJ is going to slow walk the approval process and probably backlog a lot of the approvals. How long that will take, we don't know. So technically, there would still be a roster, but the DOJ could not prevent handguns without microstamping, magazine disconnects, and loaded chamber indicators from going on that roster. And essentially, that kind of implodes the entire design and intent of the roster, but the DOJ will probably try to slow walk the process. But I do want to point out something kind of ironic and very interesting based on another case and another set of cases that just had hearings today in the Second Circuit. Today, the Second Circuit heard 5 concealed carry cases over essentially the fact that the Second Circuit stayed multiple positive preliminary injunctions without a proper hearing and briefing. What happened in the Second Circuit is New York passed their CCIA law in response to Bruin. There were multiple district courts, federal district courts, that heard the constitutionality of the CCIA and in fact sided with the Pro 2A side and issued preliminary injunctions. Well, then the state of New York said, well, we don't like those preliminary injunctions, so we're going to appeal this up to the Second Circuit, and also we're going to seek a stay of those decisions. Does that sound familiar at all? What is probably going to happen here in the state of California with the handgun roster? It's going to be likely identical. Now, what ended up happening in the Second Circuit is the Second Circuit issued kind of just blanket stays. They just issued their stays, didn't give a rationale, they didn't provide a hearing, which became a huge issue, not just in those cases, but became a huge issue for the Supreme Court. What ended up happening in a handful of those cases in New York is the plaintiffs in those cases and their attorneys then sought emergency review up to the Supreme Court. They sought for the Supreme Court to review those stays and to remove those stays because the Second Circuit did not provide hearings and did not provide any briefings or any rationale for their granting of those stays. And ultimately what the Supreme Court did is they remanded those cases back down. They said, Second Circuit, do your job, have a hearing on all these cases for why you're granting those stays, whether or not a stay should be granted or lifted, and whether or not the lower court was correct in issuing their preliminary injunction. Again, does any of this sound very familiar and probably what's going to happen here? So I believe right now CRPA, Michelle and Associates have a lot more tools in their tool belt to even fight the stay that maybe the state of California is going to seek from the Ninth Circuit. If the state of California seeks the stay from the Ninth Circuit and the Ninth Circuit just kind of issues a blanket stay, doesn't provide a rationale or an order, or doesn't provide a hearing, well then Michelle and Associates, CRPA, could try to do the same thing. They can try to use the same mechanism, take this up to the Supreme Court on an emergency basis, and seek for the Supreme Court to remove that stay, and that would be a huge win for us. The Supreme Court has already indicated that they want these lower courts, these circuit courts, to do their job in reviewing whether or not a stay should be granted or not, and just not simply blanket just grant them. So again, what's happening in the Second Circuit is going to have huge implications here as well. And I don't think it's just as simple as saying, well, the Ninth Circuit is just going to issue a stay. If they just flippantly issue a stay like the Second Circuit originally did, I think that allows for an avenue to then take this up to the Supreme Court to correct that issue. And while all this is happening, the 14 days is running, If the Ninth Circuit decides that they need to set a hearing or they need to have time to issue their own order, the 14 days could run, and there's potential that maybe there could be an opportunity for these manufacturers to then submit their firearms to get them on the roster and maybe even to be sold to individuals. So there's a lot of kind of legal process and legal strategy that's going to now play out. I wholeheartedly believe in Michelle and Associates and CRPA that they will do a great job. But those are just some of the thoughts I'm having now because, again, we had the Second Circuit hearings on this very issue. And if the Ninth Circuit kind of tries to take the same route that the Second Circuit did with just flippantly issuing stays, I think they're going to find themselves in the same trouble that the Second Circuit found themselves in with the Supreme Court. So that's where everything stands. Those are some of my thoughts about where I think this may go. Again, 14 days stay is currently in place. It's not like you can walk into a gun store. I want to make that clear once again because I'm still going to get asked that even after mentioning that multiple times on this video. But we will now wait and see about the appeal and whether or not the Ninth Circuit is going to grant their own stay. Now, if anything else develops, of course, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, subscribe. All those things help to fuel the algorithm, and it's signal to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.